Have you ever heard the phrase power of attorney only to wonder what it meant legally? If you are considering granting someone a general power of attorney, it will be one of the most important decisions you'll ever make. Needless to say, selecting someone you inherently trust to handle all of your financial, health, and legal affairs is not a process you should take lightly. But it will also help to know all you can about general powers of attorney. While you may already know that granting someone power of attorney allows them to make legal decisions on your behalf, you may not be aware of all the sweeping powers you're handing over. The first trick to navigating the wording of your general power of attorney is to know what parties are involved and what they're called. The creator of the power of attorney is called the grantor or principal. This is you, the person granting someone else your powers of attorney. The person you choose to give these powers to is then referred to as the agent or attorney in fact. Please note that here attorney does not mean lawyer. In fact, typically the agent must only be a competent adult over the age of 18, and most important, someone that you trust. Perhaps the most distinguishing feature of general powers of attorney is the amount of legal power tendered to the agent. Unless limited, once your general power of attorney is handed over to the agent, they'll be able to make financial, legal, medical, and business decisions on your behalf. Essentially, the agent has the legal power of your signature. The agent also has access to information that would have only been accessible to you before, allowing them to maintain and manage your properties, as well as make gifts and charitable donations on your behalf. Because of the immense amount of power transferred, it's especially important to be able to legally verify its authenticity. To accomplish this, each party signing the document will list not only their name, but their address. The document will also outline all the powers being authorized to the agent in great detail. After the contract is signed, a general power of attorney should be notarized in order to support its authenticity, should it ever be called into question. In some states, witnesses must also be present during the signing process. While a general power of attorney will grant the agent an immense amount of power, the grantor always has the capability to revoke that power and reclaim it for his or herself. This can be done at any time. Additionally, upon the death of the grantor, the general power of attorney will be revoked automatically, leaving the grantor's estate to be managed by the appropriate parties according to the grantor's will or as the probate court sees fit. There are no powers of attorney that allow an agent to continue managing the grantor's affairs beyond the grantor's death. Now you know the basics and have taken the first step to creating a valid and enforceable general power of attorney. Additional information and attorney-prepared powers of attorney for every state can be found at www.findlegalforms.com. Good luck.